and Osam, and he will have 30 minutes. But of course, as I've indicated,
what do you make of the fact that they basically told me to shut it and sit up? So, I mean,
hello, Mr. Katz, I'm giving you now a chance. Of course, a lot of points have been debated between us and counsel who have come before you, and some of the points might not need to be repeated, but this is your opportunity. Thank you. Are you going to make use of 10 minutes without interruption, or are you ready to be interrupted?
May I make use of 5 minutes, Acting Chief Justice?
5 minutes, okay, okay, all right. Okay, go ahead.
And I will try not to repeat arguments, although there will be some overlap, because the points that I will repeat will feed into my broad argument as a whole. Let me say both my clients submit that the relief sought by the IEC should be dismissed. And we do ask for costs, as an intervening party would. We'd be entitled to, along the lines of the Mashlope case. Now, let me indicate to the court that I intend to address the court in 3 big chapters. And each chapter will have subheadings. The first chapter I'll deal with a range of high-level propositions which the court we submit should engage with before even considering whether to give the IEC any relief, even were this court to take the view that it has the power to do so. The second chapter, I'll turn to our heads of argument and explain what we would submit would be a difference in approach to us compared to the IEC, and it's an issue of distinction that we make different to those of the other parties opposing. And that relates to, for example, the question of a state of emergency and where that might fit in the big picture of the particular case. And then the third chapter will be a very short chapter indicating why, on the facts of this case, the high-level propositions that I make in my first big chapter call for the IEC case to be dismissed. So the third chapter will be a loop back to the first chapter. As part of the first chapter, I make the following high-level propositions, and there are 4 of them. The first is the context of this case. And the context of this case has a number of features which indicate not necessarily a red light, because I know the absolutist position is a red light, but certainly a very sharp amber light flashing before this court's eyes. It's certainly not a green light, but a sharp flashing one. Let me explain what those features are. There's 6 of them. The first is this is an application for direct access. Unusual and rare. 2, it's urgent. 3, importantly, it's based on contested evidence, where this court is sitting as a court of first and last instance on the basis of contested evidence, not only by those parties who oppose, but even by the applicant itself, which presents a report of Moseneke, former Justice Moseneke, where there was evidence before him, where I should just read from paragraph 52 of our founding papers, where he said, that was the evidence of Professor Karim. If you look at these scenarios, October is probably a safer bet than going with December or March. That was evidence before Moseneke. The 4th proposition in this first item of the big chapter is that this case is being...
Mr. Katz, I'm sure you mean to say Justice Moseneke, not Moseneke.
Well, Justice Majid, it's an important question that you raise. Because
no, I'm asking something else. I'm saying you keep on referring to Moseneke. Surely you mean Justice Moseneke.
I'm answering the question. No, Justice Majid, I mean Moseneke inquiry. Perhaps I should have said, because when he gave the report to this court, he didn't give it in his capacity as a justice of this court. Perhaps I should say retired Justice Moseneke. I'll respect the office, and I have a very deep and very important understanding that Justice Moseneke is a very important person in my life on a range of levels, Justice Moseneke. But as far as his report is concerned, the fact that he was a justice should play no role in this court's consideration of the issue. The fourth proposition on this first chapter is that this court is determining the matter without Parliament being a party or Parliament playing any role in this case or in the lead up to the relief sought at all. The fifth proposition on this first chapter is that what is being sought are serious constitutional issues. They are radical. And when I say they are radical in this sense, and I want to emphasize this proposition. When a court strikes down legislation, that is radical. But it's now become commonplace. But what happens in what's being asked for here is not for that, what I'm going to call relief sought on a temporal basis, but this is final in effect. So in other words, when a court strikes down legislation and gives a just and equitable remedy pursuant to the declaration, Parliament is always free to reenact the legislation in a way that satisfies what this court indicates was the problem with the legislation. And it's not final in effect, any reading in. That point was made first by this court in National Coalition for Gay and Lesbian Equality versus the Minister of Home Affairs. Here, the Constitution demands that an election be held by the 1st of November. Were this court to grant that relief, that would be final forever. No party, the Parliament, the IEC, no person could ever undo that radical intervention. The sixth proposition that I make is that the pandemic, which has been around since March 2020, has been dealt with by way of a state of national disaster under legislation, the Disaster Management Act. And it has continued for the last 18 months. I think the first declaration was for 3 months, and then it had been extended for month by month thereafter, without Parliament playing any role whatsoever in the violation and infringement of the rights contained in the Bill of Rights, including perhaps rights which are non-derogable in the state of emergency. So that's the first proposition. The context of this case is to be considered with those 6 propositions in mind. And I turn to the second leg of my first chapter. And the first leg is this, that there was a debate.
I just mentioned, Mr. Katz, that the 5 minutes you said you wanted to have is up, but you can continue.
Thank you, Chief. Thank you, Acting Chief. The first proposition in my second chapter, in my first chapter, but the second point in my first chapter is this, that there was a debate about in comparing, Mr. Trengrove started this morning by saying there were these 3 constitutional requirements for an election. 1, regular, free and fair, and safety is the 3rd. And he was wondering why the regularity seemed to trump the other 2 when it came to those opposing. And my answer is very simple, and there's a good answer for it. 159 is absolute in its terms. There must be an election by the 1st of November, whereas the freeness, fairness, and safety are all on a spectrum. And there's no gold standard. There's no absolute guillotine, which says that this election is free and fair, that is not. And this is practiced all over the world. Freeness and fairness is context dependent. And in a pandemic, it may be very different to in a non-pandemic situation. That's the second that's the first proposition. The second proposition is throughout the day, I've heard of this notion of the election on the 27th of October. But the reality is that there will be many elections. So when it comes to provincial and national elections, there is 1 national election and 9 provincial elections. There are 10 separate elections. And it may well be that in province X, there was a lack of freeness and fairness, whereas in the other 8 provinces, it was fair. That doesn't mean to say the entire national and 9 elections then fall. It would be fact dependent upon the particular situation in that particular province. And similarly, when it comes to local government elections, there isn't 1 local government election. There are many for every single ward in this country. So we would submit that that is a factor to be taken into account in determining this question of the impossibility of holding a free and fair and safe election throughout the country. There may be certain parts of the country, there may be, which a challenge thereafter may succeed in respect of it not being free and fair. But to say today that every single election in this country in respect of every single municipality will not be free and fair and safe for the reasons that have been advanced by the IEC, we would say ought not to find favor with this court. The next proposition that we make is this. I've mentioned the role of Parliament, and the court knows, and it's a heavy burden on the court to read legislation down. In other words, wherever a court has the obligation to consider a challenge to legislation, the court will read the legislation, if reasonably possible, and I'll talk about Hyundai, in a manner that saves the legislation. Why shouldn't that same proposition, let's call it a reading down proposition, apply to that which the IEC asks for? Read, if you can, reasonably, the possibility of an election going forward being free, fair, and safe, and avoiding the violation of the guillotine. So that if this court has to think, well, the IEC have put up strong evidence as to why it's not free, and I turn to the acting Chief Justice's examples 2 days before an election, a party comes. What a court will do in those circumstances is do whatever it can to save the election, save the legislation in the challenge to the legislation case, rather than, let's call it striking down the legislation or coming to, in this case, the analogy is coming to a conclusion that the election on the evidence would not be free and fair and safe. So it's a reading down by analogy argument. And we would submit that if one takes that analogy, it's very hard to come to the conclusion that the only reasonable possibility on the facts, contested as they are, I've read Professor Karim's argument, evidence, medical evidence, that October is probably a safer bet than going with December or March. We submit that the constitutional courts, the jurisprudence of this court is save rather than strike down. So that's how we would articulate the case. And I want to turn to where we add what we would call certain distinctions to the others. And all the arguments that I've already made, all they do is they support that which our learned friends opposing have already argued, in a sense that I've added certain nuances to it. In paragraph 4 of our heads of argument, we say at the heart of this application lies the important question for the democratic project. And two questions arise. In what circumstances, if any, may a local government election be postponed? That's the first question. In what circumstances, and when I use the word postponed, it's not just a postponement, it's a postponement beyond the 5 years plus 90 days. In other words, in what circumstances may a local government election be held outside the 5 years plus 90 days? And the second question, which is also fundamental to the case, is who has the power to decide that? That first question. What are the circumstances? Do the circumstances, as articulated by whoever has the power to decide, arise in the particular case? And which is the particular body? Is it the IEC? Is it the minister? Is it Parliament? Or is it the court? And we answer, that's in paragraph 4 of our heads of argument. And we argue that the Constitution in paragraph 6 is not silent on this issue. And we submit that the Constitution itself provides the answer, even in so-called impossible circumstances.
Thanks.
So I turn to that. In paragraph,
I'm sorry, Mr. Katz, there was some voice that came through, but I think it's gone away. Continue.
Thank you, Acting Chief Justice. So the first So turning to paragraph 9 on our heads of argument, which is in chapter 2 of the heads, it says, when may an election be postponed? Reading 159 through its history. The history of 159 has not been dealt with by any of the parties. The scheme of the constitution and the structure of government. As far as the history is concerned, I'll make the simple proposition that prior to 1998, there was no window of 90 days. And the 90 days we submit is provided for in order for the types of exceptions to the 5-year rule to be played out. So it's not as if a municipal council has 5 years plus 90 days. It doesn't. It has 5 years. But in exceptional circumstances, the drafters of the constitutional amendment in 1998 decided that there would be certain circumstances where the 5-year period may not be sufficient in exceptional circumstances for an election to occur before the term of municipal councils has ended. So it amended the provisions of 159 by Act 65 of 1998 to say that the election must be held within 90 days of the date that council was dissolved. It's an amendment, and we submit that history should point to the kinds of amber lights that flash when this court considers the request that we now 5 years plus 90 days, as if this not, so it really is a 5 years plus 90 days council. It's not, it's a 5-year council. The second proposition so that's the first answer on that aspect. The second answer is this question, which I know will have us all, including myself. I'm old enough to remember 1986 state of emergency. And we all sort of put up if I had hair, my hair would stand on my back when I hear state of emergency. And the point is this: a state of emergency allows for Parliament, without a supermajority, to make laws, and I understand that there can be some debate, and I'll explain to the debate, make laws which derogate, and the legislation doesn't have to pass through Section 36. It can make laws which deal with the state of emergency in a manner that protects the life of the nation, etc. The declaration would be necessary. And there are various important safeguards when it comes to the state of emergency. And any legislation giving effect to that state of emergency, importantly, would need to be strictly necessary to the state of emergency, number one. And number two, it could be challenged in Parliament in the normal course. Section 37 provides all the kinds of protections that would and could exist, including Parliament's role, even in a state of emergency. Here, none of that exists. None of those protections exist in this lower level of an exception to the constitutional project. A state of emergency is one of those exceptions to the regular kind of situation that we find ourselves in. State of disaster is also an exception to the regular rule. In a state of disaster, we've had to stay at home. We haven't been allowed out. Tonight, there's a curfew at 10 o'clock tonight. That's the exception, not the rule. There is no parliamentary oversight to that curfew rule. And what we submit is this, that to the extent that there is to be an avoidance of the guillotine of the 90 days, the 1st of November, where is Parliament in all of this? When we know even in the most radical scenario, which is a state of emergency, where even our rights under Section 19 can be derogated from without the need for Section 36 justification. Parliament has to oversee that. Courts will check on that. But here, we don't have any of that. So as far as my second chapter is concerned, we submit all these features suggest that the direct access urgent contested evidence application, raising for the first time a what I would call temporal radical solution to a constitutional problem. When I say non-temporal, striking down the legislation is temporal. Parliament can always fix. Here, after the 1st of November, it's too late. We suggest that the court must have its amber light role very heavily flashing all the time. And I turn to the facts. I just need to read that Professor Karim again. October is a safer bet than other. And I look at my client's founding papers. When I listen to the parties supporting, I wonder the relevance of whether a particular party has had its branches ready or its candidate list ready. And I look at my client, my first client, the 5th intervening applicant. In paragraph 15, the ATM says it has candidates in every ward in the country ready to lead. The relief sought by the Commission has a direct and substantial effect on each of our ATM's candidates who put themselves forward for election. My client's rights, my client's preparedness, readiness for the election would be seriously compromised on the evidence, uncontested. So it goes. And I don't want to make too much of it, but the proposition is that that's what's sought. Sorry, that's what the government of the evidence by a postponement in the particular circumstances. So we would submit as a factual matter all of the kinds of things that the court has heard from Mr. Jamie, Mr. Du Plessis, Mr. Bishop, and Ms. LaRue all suggest that the amber lights that have flashed flip over to be a red light for the kinds of relief that are sought in this case. And we ask that the application be dismissed.
Mr. Katz, just there could be municipalities which have collapsed. And the only hope of the residents there is that October the 27th might come as a relief. And some of these might be under administration. Doesn't that add to the list of the evidential problems that might be encountered?
As we understand the constitutional protection for those residents in respect of whom municipalities have collapsed is section 139 of the Constitution, where administration is either imposed, and in particular, that's 139 1A and B, I think, and 139 1C, which is a particularly radical intervention where the province, the MEC, dissolves the municipality and a by-election would take place within a certain period if the minister and the NCOP approve the dissolution of the municipality. Again, I highlight, and sorry, Justice Saletsi, even in those 139 1A and B provisions, there is the requirement that the minister and the NCOP approve in the various periods, and I know there's some debate amongst the cases about how that would work. The minister, I think, is 30 days, the NCOP is 180 days. It's not quick. I think there's one case which says that they both have to not approve before the intervention falls away, and other cases say it's not. The proposition that I'm making, Justice Saletsi, is this. Even in those, again, unfortunate municipalities, there are protections which are set out in the Constitution, and there's no need for purposes of the debate for the election to be held after the 1st of November in order to, for example, add extra protection to those unfortunate municipalities. In fact, we would submit that that's a good reason for the election to go ahead before the 1st of November because of what is seen. And there's no evidence, if I understand it correctly, there's limited evidence. I know that my client says in paragraph 13, my client's ATM success cannot be separated from the fact that South Africans are desperate for change, particularly at local government level where corruption is rampant and service delivery poor. And there is evidence of that kind through the papers. But to answer your lordship, to answer Justice Latze, we would submit that to the extent that there are these collapsed municipalities, that's another good reason for the election to go ahead before the 1st of November.
Thank you.
I think there are no further questions from my colleagues. I think you had said you were done, Mr. Katz.
I have nothing to add.
Yes, okay. Thank you very much, Mr. Katz. I will now give the opportunity to Mr. Gauntlet who appears for Freedom Under Law.